Welcome back to the Law Stash channel. My name is Anton Vieltsin and I'm a criminal defense attorney in the Southern District of California. This is the second video in a 5-part series where I discuss vehicular searches without a warrant. In the first video, which I encourage you to watch first, I've discussed consent as it related to the Fourth Amendment requirement of a warrant and vehicular searches. And if there's one thing you should have learned from that video is don't ever consent to a search. Now that we're moving on to the second video, here I will be discussing searches incident to a lawful arrest. And I will not discuss a particular case like I usually do in detail. Instead, this series is designed to give you an overview of how searches work as they relate to vehicles. After all, one of the most common ways that we interact with law enforcement is then when citizens get pulled over. So it is important for me to discuss these cases, and I hope you enjoy this series. So let's now move on to searches incident to a lawful arrest. The first thing that you need to remember is that the Fourth Amendment protects you against unreasonable searches and seizures, meaning that generally speaking, the officers need to get a warrant before they can search or seize you or your vehicle. But now we're going to move on to exception, search incident to arrest. It wouldn't be the law without exceptions, and the Supreme Court has enumerated a number of them. Search incident to arrest is not only an exception to the warrant requirement under the Fourth Amendment, but it is also a reasonable search under that amendment, says the Supreme Court in U.S. v. Robinson. Remember, the Fourth Amendment says that only unreasonable searches are invalid. And the Supreme Court says that search incident to arrest is a reasonable search. There were two rationales given by the court in Robinson. The need to disarm the person, because after all, he's being arrested, and to preserve any evidence for trial. The idea is that there's some danger to the officers when they arrest the individual to take him into the patrol station or jail, so they need to disarm him and take all the evidence from him. There were a number of requirements for search incident to arrest to be a valid search. There has to be a lawful and custodial arrest. In fact, some people call this a search incident to a lawful arrest. And maybe I should have put that here, because after all, the arrest has to be a lawful one, meaning that there's probable cause existing that the person committed a crime. And then the arrest actually has to be made. There was a distinction in Knowles versus Iowa where the cop decided to simply give the person a ticket. He could have arrested the individual, but he chose to simply ticket him. Well, this is a distinction here. This is no longer search to incident to a lawful arrest because the individual is not being arrested. He's only giving a ticket. And so this first rationale of needing to disarm an individual, well, there's less danger if you're deciding to give the individual only a ticket and not arrest him. So under Knowles versus Iowa, we know that if the officer decides to only give a ticket, that is not a search incident to arrest scenario. And we must also make a distinction between Terry versus Ohio. Remember the case where the officers can pat the individual if the person is armed and dangerous, and if there's enough evidence that there's some criminal activity that's afoot? Well, that's again different. Terry versus Ohio is not a search incident to a lawful arrest. The second requirement under search incident to arrest is that the search must be substantially contemporaneous with the arrest. What does that mean? It means that in U.S. versus Turner, a Ninth Circuit case from 1991, that the search happens at about the same time that the arrest does. And then there were a couple of distinctions later on. For example, in Willis, the defendant was transported to the jail after the search. So the search happened before he's being transported. That's okay. And then in Lugo, the person was removed and then the scene was searched. Well, that's not permissible. And so there's some distinction between when the search actually happens. And then we have to move on to the scope, meaning what can the officers actually search under search incident to arrest exception? Well, in Chimel, which I have discussed in great detail on one of my previous videos, I will link it here above so you can click it and watch it. But the idea there is that in 1969, the Supreme Court tells us that it is the person being arrested and the area within his immediate control that can be searched. So in that case, we weren't dealing with an automobile. The idea is that when the person is being arrested, any weapons that are on him are dangerous to the officer. There's a need to disarm him. But any weapons that are around the individual are equally dangerous. Of course, the person can lunge and grab a gun from a place nearby as long as he can grab it and hurt the officer. The idea is that search incident arrest will cover those areas as well. And then in Belton, in 1981 case, again, this is the case I've discussed in great detail. So click on the video above, watch that video as well. This case dealt with automobiles. And Belton told us that passenger compartments of the automobile can also be searched. All the contents of any containers can be searched that are within reach of the individual. And by the way, the containers in Belton were characterized as any object that can contain or hold another object. And finally, under Belton said that we can't search the trunk of the vehicle under search incident to arrest. So now you hopefully understand what it takes for a search to be called search incident to arrest. You understand what the officers can actually search under this exception. And finally, I want to make a distinction. In part 4 of this series, I will discuss inventory searches. Once in a while, I get a comment in one of my videos saying, why do the officers need to have search incident to arrest when likely in vehicular situations, if the person is being arrested, the officers will impound the vehicle and then the impound exception will cover any search inside the vehicle. Why do they need to go under the search incident to arrest when they can always search vehicles under inventory searches? Well, I want to make a distinction. Both of these exceptions are different. For example, I had a case a couple weeks ago that I've discussed on this channel, Chavez, a 10th Circuit case from 2021. I will link it here above. In that situation, the individual ended up being parked in his own driveway. And under the policy, the officers themselves could not impound the vehicle. Their policy prohibited the impoundment. So they couldn't rely on inventory searches. So the only thing they can rely on is search incident to arrest. And of course the question becomes, when does the person get moved from the scene and arrested and taken off premises? Can the officers go back and search the premises and the automobile? Well, take a look at Chavez, but don't make the mistake of thinking that inventory searches always encompass searches incident to arrest. These are two different exceptions to the warrant requirement. So what did we learn here? Well, we've learned that there's now two exceptions that I've discussed: consent and search incident to arrest. I hope you enjoyed this video, and I hope you're enjoying this series where I don't discuss every case in detail, but I'm giving you an overview of how law enforcement should act when they're stopping you and they're conducting searches pertaining to vehicles. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you'd like to purchase one of these awesome t-shirts, go on my website, at lostdash.com/merch. Thanks for watching.